Hello and welcome to Legalese. I'm Ernie Hyde, your host. Legalese is brought to you on a monthly basis by the Northern Middlesex Bar Association. And we're going to delve into the mystical world of trust today with Robert C. Markley. Welcome, Robert.
Thank you.
Robert is with the law firm of Thomas A. Gibbons in Ayer and comes to us with a wealth of knowledge on trust instruments. So let's talk about a trust. We talked last month about trust in general and what they basically were. But I think it's hard for the layman at least to appreciate what a trust is. So if you could kind of just give us an overview as to what a trust actually does.
Okay, well, a very basic overview. When you create a trust, you transfer assets, whether those be stocks, real estate, things of that nature, into the trust. It is a separate entity, and it is managed by one or more trustees for the benefit of one or more beneficiaries. There are differences between revocable and irrevocable, which we'll get to. Mm-hmm. The primary one is that in an irrevocable trust, you are basically giving up control of that asset, and there are specific reasons why you would do that, which we'll get to a little bit later.
Yeah, entirely. The interesting thing about a trust, at least from my point of view, is that the ownership of the assets that you speak of, the ownership is divided once they go into a trust. The trustee has a certain ownership interest in those assets, and the beneficiaries have a different one. Can you explain that?
Yes. So the trustee will have what's called, they'll have basically equitable title, but they won't own the property that's in the trust.
Right.
Ultimately, the ownership will go to the beneficiaries. They're the ones who will receive the benefit of the assets that are in the trust, but the trustees have legal control over them. So if you are selling a house, say, that you've put into a trust, when it comes to signing the paperwork, it'll be signed John Smith as trustee. So they actually have the legal title and have the ability to control the asset, but they don't actually own it, because the end result is whatever value in the assets in the trust will ultimately go to the beneficiaries.
Okay. And so the trustee and the beneficiaries and what we call the settlor, or the person, the grantor, whoever created the trust, can all be the same person?
Yes. Although, depending on the purpose of the trust, you might not be able to do that.
Right.
So there are, the interesting thing about trusts is that you can create a trust to do just about anything as long as it's legal. Now, there'll be specific requirements depending on what the purpose of the trust is.
Right. And some of the purposes of having a trust would include things like taxes.
Correct.
Right. Minimizing exposure to liability.
Correct.
Distributing those assets to your family,
Right.
Beneficiaries in general.
Yeah,
Doesn't have to be family.
Well, we'll start with a very basic, what's called an inter vivos trust,
Okay.
which is a trust that's created within your lifetime. The alternative is what's called the testamentary trust, mm-hmm. which is created within your will, so that when you pass, the trust is created as part of following through with the will.
Okay.
Now, as far as the specific purposes of that, a lot of people use trusts for real estate, mm-hmm. whether it's their residence or for commercial. Without trying to get too far off topic, one of the examples of a trust for a commercial residence, such as an investment property, if you create a separate trust for each piece of property, then if you end up being sued by somebody, they would have to sue that specific trust holding that specific property. Now, if you have one trust and you put all of your investment properties into it, if something happens with one tenant, they can sue you, and then they could sue the trust that holds everything. So you can create as many trusts as you want. They just have to have what's called a res in it. So it has to be funded.
Right, okay. And the trustee is a pretty important person in the trust in that they, as you indicate, legally have responsibility for the direction of the assets. What are some of their basic responsibilities, though? What is their relationship to the beneficiaries?
They have a fiduciary relationship, which is the same as doctor-patient, attorney-client, which means that they have to act in the best interests of the beneficiaries, and if not, they can be held personally liable for negligence, intentional misdeeds, things of that nature in their capacity as trustee. The trustee can be an institution, such as Cambridge Trust Company, or it can be an individual, either yourself or a family member. Normally, and it might depend on who the beneficiaries are when you're determining who the trustee is. So if the beneficiaries are your children and you're creating an irrevocable trust for taxation purposes, you might want to consider having one of your siblings, one of the beneficiaries, aunt or uncle, be the trustee, because it's more likely that they won't breach that fiduciary duty than an independent third party. Although they would, whether it's an independent third party or an individual, would still ultimately be liable for breach of that fiduciary duty. Right. Also, with the trustees, you need at least one, but you can have as many as you want. You should have an odd number. That way you can't have gridlock. Right. Because if you have more than one, the standard language is generally that a majority of the trustees have to agree. So you'd want an odd number. Within the trust itself, you can also create a mechanism for removing trustees and replacing them with new trustees, and you can make the basis for that any number of things.
Okay. And there are a number of different kinds of trust, and I know that you probably run into the same thing I do. When I'm driving home from work one night, I'll hear an ad about you absolutely need to have a trust, and you should call us because we're the experts in trust, whoever it happens to be that's advertising, and the next day the phone rings off the wall because everybody thinks they need a trust. Does everybody need a trust?
Absolutely not.
Okay.
One of the difficulties with those commercials or seminars that some attorneys give at hotels, and they come ready with full packets of trusts that just need to be signed. A trust should be individually tailored to your specific needs.
Kind of like a will.
Exactly. I've heard stories from people that have gone to, heard that radio commercial or gone to a seminar. They put their house in a trust. It turns out it's an irrevocable trust, which means that if they need money for something, they can't sell the house and take the money. You can sell the house, but the proceeds have to go into the trust, and you don't have access to it. You would just have access to the income coming out. But if you have a major medical bill, somebody has to go into a nursing home, you wouldn't be able to just withdraw all that money from the trust. That's one of the drawbacks of an irrevocable.
Which brings up another point, though. An irrevocable trust could also help in a situation where you have the nursing home situation.
Yes. So right. And
depending on when it was put in.
Right. That is one of the benefits of an irrevocable trust, is for either taxes or payments for the nursing home. There's a 5-year look back.
Correct.
So what happens is any assets that you have put into that trust, and this is part of Medicare or Medicaid planning, right. If you are anticipating medical bills, whether you've started to have some problems or whether you have a family history that you're susceptible to, you could transfer the house into that irrevocable trust, or bank accounts, whatever assets you might want to put in there. And then that way, when you start drawing on Medicaid, if you end up drawing Medicaid to pay for your health care, when you pass away, the Division of Medical Assistance will put a claim on the estate, your estate, to try to recoup the money that they gave you in your lifetime.
Right.
Now, and they will look back 5 years from your date of death to try to find that money. So if you have put assets into an irrevocable trust and structured the trust properly, and you've done that at least 5 years before you start drawing on Medicaid, then when you pass away, the Division of Medical Assistance will not be able to access what's in that trust.
Right. And that also applies to entering the nursing home and the 5-year look back from the time that you enter the nursing home as to whether or not you transferred anything into that trust as well, right?
Oh, right, I'm sorry, from when you start drawing Medicaid.
Right.
I'm sorry, I
Right.
should have clarified that.
So
At the time of your passing is when they'll put the claim
they'll
on the
put the
estate.
claim in, right? And so some of the other ones I have listed here, and they are by no means an
It's not an
exhaustive list,
exhaustive list.
but credit shelter.
Yes.
Couple sentences. Give me credit shelter. What is it?
Okay.
And how do we use it?
So this is another one that you can avoid, essentially kind of paying taxes on. What happens is you create a trust with your children as the beneficiaries, and then you have your spouse as the trustee, but allow her to have access to the assets in the trust during her lifetime, which is a little different. Many trusts, and again, there you can structure it so many different ways, but many trusts do not allow the trustees to access the assets. It's meant unless they are specifically going to be dispersed to the beneficiaries. So it's a more flexible trust in many ways.
Okay. And mainly would protect some of those assets, if not all of them, from
Creditors.
estate taxes.
Right, and estate taxes, a number of things, yes.
Yep. Okay. Qualified personal residence trust.
Okay. This is another way to avoid a transfer tax, among other things, so that what would happen is you transfer the residence out of your name, and you end up paying, and you say have the beneficiary would be, say, your children. What would happen is you could do that conveyance under a relatively low gift tax. So there's ways that you can play around with the taxes that you end up paying on assets in the trust. And again, it's going to depend on specifically what the trust was created for. So there are pros and cons to any type of trust.
Right.
So you might want a trust to do one thing like the generation skipping, where you would, instead of naming your children as the beneficiaries, you would name your grandchildren. So because it skips that generation, there isn't that inheritance tax. So
Right.
it's really what the ultimate purpose that you're trying to achieve will determine the type of trust that's best for you.
Right. And every one of these trusts, as you pointed out, has beneficiaries, whether
Yes.
they are the person who started the trust, created the trust, or some family member or members or whatever. But when all is said and done in this trust, someone is going to receive the assets. And we have rules against perpetuities. And I don't want to get into that because it'll take us all night to describe it. But there is a finite amount of time that this trust can go on. It's not forever.
Correct.
Right? Okay. So when we talk about things like blind trust, and we talk about charitable trust and so on and so forth, we can put things into a trust for the purposes of distributing to beneficiaries called charities, for instance, which again is a reason to do it is a tax reason. But they only go for a certain amount of time. And at the end of that time, the trust has to end.
Yes.
Correct? Okay.
Right. There are a number of ways that can be structured. So you could say in the trust document that this trust will terminate after 20 years. You can say it'll terminate after 40 years. It will terminate at the death of the last living beneficiary. And in that case, say you have, you create a trust for your grandparents, and they might not, live that long. You can say in the trust that at the passing of the last remaining beneficiary, any remaining assets in the trust will be dispersed in this way. So it's almost like a will. So if there are, so you can have a trust that will terminate as soon as there aren't any assets left. Once all the money's been distributed, you could terminate a trust by a certain number of years, and in that termination, you can determine a disbursement of any remaining assets in the trust at the time of termination.
Yeah, and you brought up a very important point that we have completely ignored up to now, but I want to bring it up, in that it is very similar to a will in many respects. It doesn't actually do everything that a will does for different reasons, but the assets that are passed upon death are treated the same way as they would be if they were passed in a will, number one. But the will also, the trust also is managed outside of the probate process.
Correct.
So we don't go through that process.
Right. If you do your estate planning properly, you will not have an estate. So I'm sure you've touched on this.
Be careful how you say that, because I'm not sure everybody understands that.
Right. Okay.
They don't have an estate. Why?
Because there are no assets.
You personally.
Right.
Because you put them into
a trust. Or
okay.
Because there's a second person on your checking account. There are a number of reasons that I'm sure you've touched on back in your estate planning. One of the other things that I think I should go over briefly is the trustees themselves and their actions, which I didn't touch upon previously. In the trust documents, the grantor, the settlor, can spell out specifically what the trustee's duties are. So say you have a special needs trust. You would want to put in language that says the trustee is not allowed to disperse sums to the beneficiary which would disqualify them from receiving any governmental benefits. You could, in a lot of times when people create trust for their children, you can say that the trustee shall only disperse funds, assets from the trust for the purposes of education, health, living. So you can limit what the trustee can do. Right. That's the opposite of a discretionary trust, where you allow the trustee to basically determine which of the beneficiaries gets what and how much. So as the person creating the trust, you can take steps to limit what the trustees are able to do. And just another quick example of ending the trust. A lot of times when I have clients that want to create trusts for their children, I'll advise them as far as distributing the trust to say, to get them through school basically first, because as soon as they turn 18, you don't want to give them a whole bunch of money. It's a bad idea. So you could put in language to say that half of the remaining assets of the trust will be dispersed at age 25. Then another half of the assets will be dispersed at the age of 30. And any remaining assets will be dispersed at the age of 35. So you can stagger how you disperse the funds from the trust, just so you don't give somebody who might be immature a whole bunch of money that they'll have full control over.
Mm-hmm. Mm-hmm. And smart way to do a trust, actually, when you're talking about your children, to consider their ages and what the possibilities are.
Right. So you could say that while in college they could disperse. So you could structure it to encourage them to behave a certain way as well.
Right. Right. Okay. Can I have an oral trust?
You really want a written trust.
Because can't get you to say you can have an oral trust, huh?
Yeah. Well, as an attorney, everything should always be in writing.
Right.
But what it really comes down to is enforceability. And
exactly.
if there ends up being some disagreement or fight between the trustees and the beneficiaries, then it's, this person's word against this person's word, and it would just be a big mess, and whatever assets are in the supposed trust would likely be eaten up in litigation.
Yeah. I'm sure you've heard clients tell you that, don't worry about that because I told my brother when I go that this is what he should do with that and he'll take care of it and so on and so forth. And I start thinking, well, you're kind of setting up a trust even though you haven't put anything in it yet, but you've already given directions for
right. So
its distribution.
Technically.
But nobody knows that but you.
Right. Technically,
right.
yes, but highly advised against.
Right. You did bring up, and I think it's very important because this is the step that I see missed more often than anything else when I see trusts coming into my office that we didn't do or had nothing to do with at the time. Them being funded.
Yes.
They're a disaster. And they're a disaster because the people who believe that they have spent all this money on having these elaborate trusts done have actually got a document that is helping them, when in fact, because that extra step wasn't taken, it's useless.
Absolutely
It might as well be white paper with no ink on it.
Correct.
Explain what I mean by funding when I talk about real estate. What takes place?
You need a delivery of the assets to the trustee. Okay. So in the field of real estate, say you and your spouse own your home and you want to put it into a trust. What you need to do is you need to execute a deed from yourselves to yourselves as trustee of the Ernest Hyde Family Realty Trust or the 123 Main Street Realty Trust. So a lot of people will use the property address as the name of the trust. But yeah, without that delivery, then that house is part of your estate and will not be protected from the probate court.
Right. And it needs to be recorded. Just as any other deed needs to be recorded.
The deed needs to be recorded. The trust can be recorded or unrecorded, again, depending on what your ultimate purpose for the trust is. Many trusts you don't want to record.
Right.
However, if you're going to be doing a lot of real estate using the trust, then you want it on record because there are trustee certificates and other minutiae that go along with the conveyance that we don't need to get into. But yes, yeah, absolutely, you would have to record the deed because that's notice to the world that the conveyance has occurred. Okay.
And what about liquid assets such as, let's say I have money with an investment house, Merrill Lynch, whoever it might be, and I've got $50,000 in an account with them. Can I put that in the trust? And how do I do that?
Is it are they holding it in an account like a bank account? Because
basically
in a Taunton,
it's not a retirement account. It's a straight, simple investment account.
Okay, so that's basically a Taunton trust then, which is a bank account that has a payable on death provision. So that's what pulls it out of the estate, similar to life estate or life insurance. If you have life insurance, you have a named beneficiary of the policy, they're alive at the time of your death, the money goes straight to them. It can't be taken by creditors through the probate process.
Right.
If you don't have a beneficiary or the beneficiary's passed away without you naming another one, then it does go into your estate. So a bank account that you hold only in your name while you're alive, once you pass, creditors can reach that because it's part of your estate. If it has a payable on death designation, then just like life insurance, upon your death, it would go directly to that person and would not be reachable by creditors of the estate.
Okay, can I put my car in a trust?
You know what? I don't think anybody's ever asked me that question, but I would
I don't think
say
I've ever
no.
done it either, but I think you can. I
that's
think you
interesting.
probably could register it to the trust, I'm not sure, or assign the title over to the trustee.
Well, you could sign the title to the trustee,
Yeah,
right? Correct.
Yeah, which may be difficult. But at any rate, any kind of an asset basically can go in a trust,
Right.
right?
Right.
And actually, when I put this show together, I was thinking about, wouldn't it be nice if we could also put our liabilities into trust and pass them off to our kids like the government is doing right now?
If I could create the Robert Markley Student Loan Trust, I would.
You would not be the only one, I'm afraid. Okay, that pretty much skims the surface of trust, but anything else you want to
barely
add
skims.
to it? I know. Anything else you want to add to it? I mean, there are all kinds of trusts we could talk about. The blind trust, which you hear a lot of
With
politicians
politicians.
Enter into.
Right. It's a blind trust is essentially you don't know what's in the trust. It's a way to shield you from political attacks, so to speak. And every once in a while you hear about politicians that, I think the last one I heard about, it was a congressman from Tennessee, I forget his name, but he was the family that started one of the huge health conglomerates. And he had a blind trust so that he didn't know what was in there, so there couldn't really be a conflict of interest because he didn't know what was there. Now, if you're running for a certain office, what the politicians will do is they will peek into the trust. And if there's anything in there that might be a conflict of interest, then they can disperse it or get rid of it or trade it out.
Trade it out, yeah.
But the purpose of the blind trust is to avoid a conflict of interest with what you're investing in. So it avoids any kind of potential maybe insider trading or just the appearance of impropriety when you're running for office.
Right. Well, Robert, I want to thank you for coming on. It's a subject that needs to be addressed in any estate plan, at least to determine whether it's necessary or not. And many times it's not, but should be looked at. And they can be very useful when they are needed. So
Absolutely.
thanks for coming on. Appreciate you looking in again on us, and hope to see you again next time.